introduce Scott Giordano, partner and co-founder of the CISO law firm, PLLC, and the SolarWinds CISO litigation and what it means for your InfoSec program. Scott.
Thank you. Good morning, everyone. I want to welcome you all to the SolarWinds CISO litigation and what it means for your InfoSec program. I'm Scott Giordano. I'm the co-founder and partner at the CISO law firm. We're the only law firm in the world that is dedicated to representing CISOs and other cybersecurity team leaders. And so it should come as no surprise that this is a subject that's very near and dear to our hearts. I'm very delighted to have an all-star panel here. I have with me one of the partners at the firm, John Barker. I also have two friends of the firm, John Bandler and John Bates. And so we're going to talk about the SolarWinds CISO litigation. And I think it's very easy to think that everything that could possibly be said about this subject has been said. I think you're going to find that's not the case. There's a lot more to talk about. This story is by no means over, and there are a lot of great lessons for CISOs and cybersecurity team leaders. So what we're going to do is we will be talking about why we think this matters. We'll go over a chronology of the SolarWinds matter, some lessons learned, and then some best practices for you all to take away back to the office. So we're also going to leave 10 minutes at the end for questions. Please save up all your questions and let us have it. This is perhaps the only time you'll ever get to ask a question to an attorney and not receive a bill in reply. All right? Okay, well, with that, I'm going to send this over to John Barker. John, the floor is yours.
So why does today matter? Why is this important? And this slide right here kind of gives the very big picture of a CISO situation as a result of SolarWinds. So number one, CISOs exist in a very tough environment. Their tenure is short at their businesses, and they're not always given executive access that they should have. So CISOs need to stand up for themselves. Number two, CISOs are now facing civil and criminal liability for mistakes made in cybersecurity. And we'll talk about what those mistakes are considered to be. Number three, you need to document your decisions, document your discussions, document your decisions. You should work with legal counsel, by the way, and get advice. You're inside legal counsel. You should also consider getting outside legal counsel to review maybe your contract of employment, get advice on getting directors and officers insurance and understanding the limitations of the directors and officers insurance. CISOs should also verify that they are a duly appointed corporate officer. That is generally a decision of the board of directors. You want that status, and you want that directors and officers insurance as well. The other main takeaway we want to share with you is it's very important to stay on top of legal and regulatory developments. You might need to hire outside counsel to understand those, but you can certainly follow them in the news. I'm going to go ahead and pass this along to my colleague John Bandler, who will talk about the SolarWinds case chronology.
Great. Thank you, John Barker. We've got three Johns up here, John B. So we're going to be on a last name basis as we discuss and argue. So I'm going to talk a little chronology. I'm not going to cover the whole chronology. John Bates will cover some too. But starting where I think we should, 1999, SolarWinds is founded. 2009, they do their first public offering. That means they go from a private company to a public company. That means they fall under the regulation of our country, the SEC, Securities and Exchange Commission, because a public company has publicly traded shares. And our country decided back in 1930 or so, after the Great Depression, our first depression, that we need to regulate publicly traded companies to try to create a level playing field, because investors are buying and selling. It's people's retirement. There need to be some rules so that information provided is shared by others, not putting out materially false information that could trick some investors and consumers, and so forth. So that's SEC regulation purpose. Now, they go from public to private in 2016. So now they're private. Now, each time they're going public and private, it's good financially for certain people, right? 2017, they post a security statement on their website. So they're a private company then. They post a security statement. One of the reasons is to make it easier to answer all these security questions they get all the time, as you know. Then they go public again in 2018. So now they're publicly now traded. Now, side note, just a couple months ago, they went private again, or they announced they were going private. So it's been an interesting kind of back and forth public-private. But it's also good to remember the reason the SEC is bringing a case is because of the time when they were publicly traded and the whole purpose of those laws and regulations. So a little bit more of the chronology, and I'm not going to get into the technical details. John Bates knows them better than me, and probably all of you know them better than me too. But I will cover just the important point. 2019, around September, we think, is the first breach, and that's been attributed to the Russian government or people acting under their direction. They get into SolarWinds. You all probably know that, right? And then by getting into SolarWinds system and their code, they get into all of SolarWinds customers. So this is a data breach, and it's not just a little data breach. This is a big data breach, right? Because all of these other companies, depending on the software, are now breached, including the US government, including all kinds of companies doing all kinds of sensitive things which a hostile adversarial nation state wants. So this case is really neat because we've got civil law, we've got regulatory law, we've got negligence law, securities law, and nation-state conflict and the laws on that and what's happening there. 2020, SolarWinds starts getting more clues. And 2020, in October, SolarWinds now has some evidence. Hey, I think there's been one compromise with our system. Maybe it wasn't our system, and then another customer's involved. Then it becomes clear our system's been compromised. So one event, 2020 November, back and forth between SolarWinds and Palo Alto, and a SolarWinds employee told Palo Alto, no, we haven't seen anything like this before. And then he texts his group chat, well, I just lied. So I'm going to talk a little about laws, and there we have a statement, an admission, it's recorded, and it's not good for SolarWinds, right? The SEC highlights that. So I want to talk a little about some legal basics. All right, so first off, law is not just for lawyers, right? You would never say knowledge of driving is just for the cops who enforce the traffic law or for mechanics or auto racers. Medicine is not just for doctors. We all need to know something about health. Law has got to be for everyone if we're going to be in a nation of laws. So we can't rely only on lawyers to tell us what the law is and what, what complies with the law or what doesn't. So laws for everyone, you included. Two main categories of law, criminal and civil. So criminal law, a cop could arrest you for. Civil law, basically a cop could not arrest you for. Usually it's a lawsuit for civil damages, for money damages. So this SolarWinds case is a civil case. No one got arrested. No one's going to get arrested. No one's going to go to jail. This is a civil case where the government, the SEC, is suing an individual and his company for violating a civil law, and the likely outcome is usually, if the complaint is found valid after a trial or settlement, the outcome would be monetary damages and maybe an order to do something. So this is a civil case. Now, I know for people in the information security community, the idea of getting sued is scary, right? That you could be personally liable. And it brings me back to 1995 when I first put on a uniform as a state trooper, and they gave me a sidearm, and they told me when I was allowed to use my sidearm. And I realized for the first time in my life, I could get sued if I get in a car crash or excessive force. I could get sued personally. And I also realized for the first time in my life, I could go to state prison. If I decide to use my sidearm to shoot someone, that's criminal law. The criminal law will either say not justified, that's a murder, or justified. So I feel you. It's scary to think you could get sued for something. But also, I'll point out, that's because this is important. Cybersecurity is important, and what you say is important about what you did or what you're going to do, and it affects share price, so it is important. So civil law covered that. SolarWinds is a civil case on the Securities Act of 1933. They'll call that the Securities Act. And then there's the Securities Exchange Act of 1934. People call that the Exchange Act. And remember, one aspect of investor protection is we don't want companies lying about things in the company. We don't want them putting out materially false information. So that's the purpose of the law. We all can debate about the facts of this case, but I think most of us agree, hey, that law does make some sense. Let's just hope it's enforced fairly. So that's investor protection. And some evidence basics. When you bring a criminal case or a civil case, and remember, this is a civil case. How am I doing on time?
Doing great.
When you bring any case, first you make a complaint. So in this civil case, the SEC brings a complaint. They write out words making allegations, and they need evidence to make those allegations. And sometimes that evidence comes from documents, records, and a lot of times statements of people. So there's a legal principle. You've heard about hearsay. You know, the law likes live testimony in court, but we've got exceptions to all our rules. So the statement of a party opponent is a way to get evidence in, because that's not hearsay. So in this SEC case, they're relying on statements of a party opponent to help prove their case. We'll talk about some takeaways on that later. But also they are trying to prove deception. So they are looking for evidence to prove that people said things that were false or recklessly false. And also with something called scienter, which is basically someone knowing that it's false or that it's not good. So these statements by a party opponent are important. We'll talk takeaways, because sometimes you're like, oh, I shouldn't write anything down or say anything because it could be used against me. But you need to say things to do your job. And if we're trying to do the right thing, we need to communicate, right? So they're looking at statements like the security statement says our cybersecurity does ABC, but there may be other statements or documents where they're saying, hey, we don't do ABC. That's admissible. And then a statement such as, well, I just lied, that's a statement of a party opponent, and it's proving deception, and that's admissible. And what happens in a legal case? Two sides arguing. So the other side will say, hey, you cherry-picked that statement. You cherry-picked from that document, or you took it out of context. So quick civil procedure. You got the civil complaint, makes those allegations. There was a motion to dismiss by SolarWinds where they said, your complaint did not properly state a claim. So there was legal motions on that, and the court ruled on that, and the court said, some of those claims were not properly stated in the complaint. Those are dismissed. And the court said these claims were properly stated in the complaint. For these reasons, those claims survive. And then what just happened, I just learned about it early this morning, is that SolarWinds just filed a motion, a summary judgment motion, which is a motion to dismiss. After discovery has happened, there's been an exchange of facts from both sides, and now SolarWinds is saying, based on all these facts we know, Judge, you should dismiss the rest of these counts because we don't need to go to a trial to decide the facts, because there's no reasonable issue of facts. And look, those are good lawyers. They put a lot of time and research into it. They're good. They're working to win the case. We're going to get the SEC's response to that summary judgment motion. And if claims are dismissed, the case is over. if any claims survive, the next phase would be a trial. And the trial is either in front of a jury or a judge, and there the evidence is presented to decide the facts. Because we're all going to disagree on what the actual facts are, and I know the facts as they've been put in the public record, or some of them, so we're going to debate the facts, but it's good to know what the law is, what the law should be, how it should be enforced. All right, so SEC focus after SolarWinds, and I just want to quickly touch on something. First off, we don't want to read too many tea leaves into this case. One, it's a single case. Two, it's a pending litigation, so we don't know how it's going to resolve or what the judge will say in future decisions. Also, change of administration, maybe a different focus on the SEC. But I will tell you, whatever happens in this case, there are takeaways that you can take away for the future because they are principles that will hold true. So after the SolarWinds breach became clear, and it became clear that tens of thousands of other companies were breached, the SEC in 2024 brought these 4 enforcement actions against 4 companies. And basically the allegation, and the companies cooperated, the SEC mentioned it, the allegation from the SEC, and the companies didn't admit or deny the allegation, was that the companies downplayed the harm from the SolarWinds. The companies knew they were breached, and in their public statements, the company said, oh, there may have been a data breach, and it may have occurred for this. And the SEC is like, whoa, you really underplayed that. You made it sound hypothetical. You minimized it. It was not accurate. So they entered into a settlement, paying fines, $1 million for about 3 of the companies, $4 million for another. And I think for one of the companies, they said also, your controls were lacking. So that pretty much covers my portion, and I'll turn it over to John Bates.
Before we move over to John Bates, some follow-up questions for you. So you mentioned the word hearsay, which brings back some scary memories from evidence class many, many, many years ago. So I don't think the audience necessarily knows what hearsay is. Please.
Yes, so hearsay, a lot of lawyers don't understand it well either. But hearsay for evidence, the law says we want evidence to be given by a live witness in court, sworn to under oath, and then the other side's attorney gets to cross-examine them. And that, in traditional law, is the true test of credibility. So that's what the law prefers. But we know in real life, you can't have people in court taking testimony live all the time. And also, there's good reasons why there should be exceptions to the hearsay rule. Like business records kept in the ordinary course of business is an exception to the hearsay rule. And also, like I said, statement by a party opponent. One side gets to pick any statement they learn about that the other side made in order to try prove their case. So in criminal law, a statement by a defendant, the prosecution got to use that because it's a statement by a party opponent, an admission against interest.
Second and final question before we move over to the next John. So administrative agencies like the SEC, they always have the option of using administrative law vis-a-vis using civil law, meaning going to court, going to trial. Would you help the audience understand that dichotomy? Because they have a lot of tools in the box, and I don't think the audience necessarily knows that from the get-go. So
yeah,
please.
Absolutely. So an administrative agency like the SEC, they're empowered to enforce certain laws and the regulations or rules under those laws. One thing they can do is an administrative action. They can do fact-finding, they can do subpoenas, they can call testimony, and they could issue an enforcement order because they have this power of licensing, which companies have to comply to. So they can do an administrative proceeding. They can also bring a lawsuit in federal court, like in the SolarWinds case, where they are bringing a case for monetary damages and maybe for a court order for something. Now, the SEC cannot bring a criminal case. They don't have that power. If they thought a criminal case was warranted, they would have to do a referral to a federal prosecutor, and then a federal prosecutor would have to decide whether to bring a criminal prosecution or not.
Wonderful, thank you.
All righty. Well, good morning, John Bates. Nice to meet everyone. What I wanted to do here is take us through a little bit more of the detail of what they technically saw and what technically happened. And I think as you kind of take a look at this, I think you can think a little bit more of like what would that appear like if that happened to you, and how, I don't know, reasonable or unreasonable it may have been considering what was happening. And I think that's the kind of context you want to evaluate this in, and obviously the lawyers had to work from these parameters. So first we're looking at late 2019, right? And so it looks like around September or so, I think it was Cozy Bear probably got in, and it really is it's a SAML attack, and that's why it's kind of called the Golden SAML attack. It ends up being, this really originates from an update server ultimately that's pushed out to all their clients, right? Because it's a SaaS solution. So it looks like say September 2019 it happens, and 2 months later, which, right, it's obviously not a great thing to find, but it's also, is it all that like uncommon to find? But we have a poorly created password that's in plain text in the GitHub that's public, okay? Not the first time it's happened, probably not the last 1,000th time it's happened, right? But nonetheless, that it's discovered at that point. So Mr. Kumar, he discovers that, and then we really have a whole series of other actions that are happening, you know, a few months later when you get to February of 2020, right? And so FireEye in particular discovers they've been hacked, and that kind of brings this out. And so what you see then is there's a lot of other actions that are coming out. We find out that indeed, you know, or at least CIS is saying that, you know, it was the Russians. You've got acknowledgement by SolarWinds of the breach, and then we're also finding out that it's the majority of the customers, right? That it's not a small action. And so what I'm doing here on the next slide here is I wanted to bring out what I consider the important legal pieces, right, of those facts. And that's why I wanted to kind of put these together, that there's technical facts and then there's ones that are, I think, legally important. And these two in particular, right, is what does that negligence look like to do that type of password in plain text? And then also, obviously, the acknowledgement via the SEC acknowledgement from SolarWinds to the federal government that indeed that has happened, okay? And so then I think we come to the next slides here that really start laying out what's happening here in 2021. So it's a decent amount of time that has moved on, and we're learning more about the technical aspects of how it happened. We can see that Chris Krebs is picked up, and you can imagine what's going on here is that they're doing deeper and deeper investigation and trying to, you know, they're pulling in outside forensics resources, right? And at the same time, pretty quickly, though, I think even today it's faster than this, but you've got a class action going on in Texas immediately, you know what I mean, as soon as that's discovered, okay? Those are the key kind of facts, and then obviously, you know, the government gets involved and so forth, and then we all kind of hear about it. But I think there's, again, highlighting what I consider the important pieces of this puzzle, right, at this point, is that you have SolarWinds acknowledging that 123 password was indeed theirs, and it was placed on the GitHub. And obviously, I think the acknowledgement of the class action lawsuit shows that they obviously know that you know, something is up, and the plaintiff's attorneys are taking advantage of it. So I wanted to kind of lay that out because there's a certain like timeline here, or there's a gap between everything's kind of discovered and then when it's kind of acknowledged and when we learn more about it, okay? So these things don't happen month, right? There's really a decent amount of time in between kind of the start and the finish of that. And so what we'll do now is John Barker is going to lead you through really what the litigation was and then how that relates to the case that we're talking about today.
So the litigation history is rather complex. So there has been action in the courts, and there was administrative action. So you'll see that the Securities and Exchange Commission sent a Wells notice to SolarWinds and the Chief Information Security Officer and some other corporate officers. And a Wells notice is just a notice, a document in which the Securities and Exchange Commission says it intends to bring some kind of administrative action. It's going to do some investigation. You do not want to receive a Wells notice. It is an ominous event in your life as a CISO or as a CEO or corporate officer in a company. You will notice also that as John Bandler noted, that the SEC filed a civil complaint against the Chief Information Security Officer, and the litigation is still going. Now, I would like to note there were original allegations brought by the Securities and Exchange Commission, and a lot of those did not survive. So it was focused on inadequate disclosure or false statements about the event. There were also inconsistencies in documentation and recorded statements among the staff. By the way, that is one of the takeaways. You want to make sure that whatever you say on your public website about your cybersecurity posture, whatever you say to your investors, you want to make sure it's consistent with internal communications. And there were allegations of inconsistency. Also, there were allegations that there were several internal control failures inside SolarWinds. So quite a few allegations. Now, the only one that survived is publishing misleading statements on the public website, on the SolarWinds website. So the court, and it's a very lengthy decision, I think it's about 120 pages long. There's a lot of fact-finding by the judge, and there were allegations that an internal team acknowledged cybersecurity failures, and that on the public website there were statements that, hey, we're doing okay on cybersecurity, we're secure. And that was the biggest allegation, was that false statement. So remember, I mentioned earlier about documenting your decisions, documenting your conversations, make sure they're consistent, and one takeaway is have your legal counsel, internal legal counsel involved. Make sure your marketing communications are consistent. All communications about cybersecurity need to be consistent. Now, the case is still active, and Mr. Bandler did note that there was a motion for summary judgment filed on April 25. It's a very interesting motion. It's full of emotion, I can definitely say. Definitely worth looking at. And you, by the way, can download this presentation, and these are hypertext links to the source documents. And of course, there has been an agreement for an acquisition of SolarWinds by Turn River Capital. But I do want to note that the judge dismissed most of the allegations made by the SEC. So it is ongoing. Also, you will see here that, well, we talk about best practices again. Make sure all of your statements are consistent. Get your legal counsel involved from the beginning. Make sure your marketing communications are consistent with your internal security posture as well. Okay, and lessons learned.
Going round robin, Scott?
Please.
All right, lessons learned. Oh, I've got to do the mic. It's too many things to hold and think about. Lessons learned. I'm going to go with I'm going to mention two now. One is lesson learned, no law and cyber law, because it can't just be for lawyers and legal. It's for everybody. We're a nation of laws. I should mention my book on cyber law is at the bookstore. My chief marketing officer said, you have to mention that. And my other 3 books are at the bookstore too. And I can't bring them home, so everything must go. So law and cyber law is for everybody. It cannot just be for lawyers. It can't be things you don't understand and you're doing it because legal said. So that's the first takeaway. The other is we need and want to communicate accurately and clearly. We have to be careful with our words. I'm not saying be afraid or fearful, but our words do matter in a text, on a statement online about our cybersecurity, whether it's for investors, consumers, anybody. Our words matter. And this is the case for any important profession, and this is an important profession. Policing is important. Every word on a report, every statement, it matters. So clear, accurate communication. I don't want to go on too long on this, so I'll let someone else talk.
Well, I just want to mention the insurance angle. So one thing you need to know is you need to understand any insurance policy that might apply to you. If you're a duly appointed corporate officer, then you can be covered under the directors and officers insurance, but you need a copy of that policy. You need to understand what its limitations are. Number two, even if you are not a duly appointed corporate officer, some directors and officers insurance policies just say, just because you have the letter C in your title, the insurance policy will cover you as a corporate officer, even if you're not formally appointed. So you must understand that insurance policy. Get a holistic view of all the insurance policies that apply to you, errors and omissions policies. Even if you're in a nonprofit organization, there is even the possibility your general liability policy will apply as well, but only in the nonprofit context. Short summary, hire a lawyer and understand the terms of coverage of all insurance available.
I think the reporting structure is key, along with access to the board. So if you guys pretended you could represent your companies, do you feel your CISO gets adequate time with the board? Raise your hands. Okay, so it's in that ballpark. I think that this is one of the issues. Is I think the reporting structure can definitely be a challenge. We don't have CISOs who report directly to the CEO, and they can be, I don't know, in my mind, pushed down in the organization, where they're underneath, say, a CIO or CTO. That can work, but it doesn't necessarily work in that way, that they're lower. The CISOs can get very, very little time with the CEO, especially compared to other executives. And then at the same time, they are in front of the board once or twice a year. And it just doesn't seem like that's enough for the CISOs and the board to meet. The other nuance is getting time with the board or the audit committee in executive session, which means it's just you and them. And that's a big difference compared to the attorneys being there and so forth. And it's not, we'll just say it's more formal and documented versus an informal discussion in executive session between the CISO and the board of the audit committee. There's a big, big difference. And so I think there's issues at that reporting structure that can prevent necessary information going to the top. So
One final note from the moderator here. Very interesting aspect about this that I don't hear very much about is that it wasn't a fancy technology that detected this breach. It was an alert employee from, I believe it was FireEye, that found it. So it's an important lesson for all of this, and I say this probably way too much, but the best cybersecurity control ever invented is an alert employee, and this is proof of that idea. So something to think about. I know we talk a lot about all the different things that are available here to buy from different vendors, but really making sure that employees know that they're on the front lines, and typically they're going to be the first detectors, if not the first responders. I think that would be my lesson learned. So in the 5 minutes we have left before we go to Q&A, do we want to talk about some best practices?
So I'll start alphabetically. I think I go first. So best practices, let me just mention one more lesson learned. Cybersecurity and breaches affect share price and company value. I think that's important to mention, and it just does. It's important for the company. It's important for people to know. and it does affect that. So best practices, you know, I have this concept of 3 things everyone in the organization should think about, and it's unhelpful in an organization when some people are thinking about compliance and they're not thinking about revenue. Some people are thinking about revenue, but they're not thinking about compliance. So I like to think of cybersecurity, and my job as a lawyer is not just compliance and protect from lawsuit, but 3 things that everybody thinks of. One is mission, which a lot of times is revenue. Everybody's got to focus on mission. Another thing is protecting the company from cybercrime. Everybody's got to think about that. I know some people more. And another thing is compliance with laws, regulations, legal requirements, contracts. So if we all are always thinking of those 3 things and speaking appropriately about them, hopefully it also helps focus our communication, which, as I mentioned, sometimes you have to phrase things a certain way, like, you're coming into a company, instead of saying your cybersecurity's terrible, you got to do this. Like I talk to a student, I don't say your paper's terrible, you're a terrible writer. I'm like, here's some ways we can improve, which also reads better in the lawsuit also. I also like to focus people on 5 components of policy work and management. And missions first. External rules is there second for me because I'm a lawyer. Our internal rules, our policies, procedures. Did I mention I have a book on policies and procedures in the bookstore? And those have to align, and then our practice has to align. We have to practice what we preach. It aligns with our internal rules and our external rules. And we're doing mission, and we're consulting external guidance. So that's the 5th, the cybersecurity frameworks and so forth. All right, who's next?
All right, John Barker, you want to?
Well, I've already noted the need to document your decisions and have consistent statements about cybersecurity. Be honest about them. Don't be overly critical about it, as Mr. Bandler just noted, but make sure you work with legal counsel, work with your marketing and communications team, your investor relations team. You need consistent communications. Understand your relationship with your CEO, your board. Get the skills you need to get access to the board and communicate effectively with the board. Understand the escalation criteria. When do you need to escalate a cyber issue to the board, even when they don't want to hear about it? And also understand what the board does not want to hear. I'll just leave it there.
All right, and John Bates, round it out.
And finally, I think one of the most important areas you need to mend in your organization is between the security department and the legal department. And it can be tough. It can be really tough because I obviously I work with security folks, every day, and I think that I don't sense any, opposition from cyber to talk to legal, but I definitely can see legal not having the right type of attorney who understands what the cyber people are saying. And that is the piece that I think in your organization, you feel as if you don't have an attorney who really understands your acronyms, the way you speak and what that means, that's a gap. And I can't tell you exactly what will fall in there, but I do feel that that is a risk because you need to have an attorney who understands exactly what the maturity of your program is so that they are controlling, in essence, what's going on in your marketing department or what's said by your PR department, because that lawyer is going to be the only person who controls it. I don't feel as if the security people are going to control what the marketing people say. I don't think it's going to happen that way. Legal is the one that's going to have the authority to do it. And if your connection, right, your liaison through the legal department doesn't really understand what you're doing or not doing and what that reasonable security program looks like, I think mistakes can happen. And unfortunately, people will, they'll try to save themselves in crisis and push someone else out. And I think that, unfortunately, we've probably seen that a few times with CISOs already, that other people from other organizations, parts of the organization have really thrown the CISO, under the bus in that way. And I think that the gap between legal and security is the relationship you want to measure. And you, from the security side, do you feel well understood by them or not? And I think that's how you go about determining if there's a gap.
Wonderful. With that, it's time for questions, folks. We have, I see 2 microphones. I say get lined up and let's knock off as many as we can.
Okay,
Really? Okay. All right. Well, make them good.
thank you. Great job. I've read the SolarWinds opinion and gone through the details of the case, and I think from a CISO's perspective, I think one of the most difficult things is how we balance the reality within an organization of we're never going to be perfect, right? We're trying to get there. That's why we have maturity models. So there's always going to be that presentation, that comment in the organization, hey, we need to fix this or that. And then there's the public view that we don't want to say we have all these vulnerabilities because we don't want to broadcast that. So what advice do you give to people in the security organization so that they don't need to bring their lawyer into everything that they document, everything that they say, so that they're actually, you know, while they're trying to build to this good maturity, that they can have this conversation and document these things internally?
So it's a good question, and I've thought a lot about it and worked with a lot of clients on this matter, and I think I can explain to security people how that should work. I think if you've studied either ISO, high trust, or you've really gone through an 800, like say 53 type of thing, where you start thinking about is that documentation and the practice that goes with it. I've got my thou shall, I have the SOP that tells you how it's done, then I should have another policy that indicates how it's going to be audited with separation of duties incorporated in it. From that, then another person takes it and it goes to your risk committee, steering committee, you have, you know, LT, however you name that. If I looked at your IAM or if I looked at your CMDB or I looked at, you know, internal threat, would I find that documentation in practice that I am literally describing exactly how we do it, how we do our internal audit, right? We just don't call it that way, but that's what it is. When we find gaps, do we create corrective action plans? Do they go back up to the committee? And then do we test again to determine whether our corrective action plans are working? This is how you show the government that you have a reasonable security program. But you are always going to have gaps and caps. It's never going to go away, but the whole point is, just like the DOJ guidance on compliance programs, is they want to see this like ISO eternal recurrence of looking at your risks. This is what's reasonable. And the more that your program doesn't look like that, the more you're looking kind of unreasonable. Because the government can come in and say, you're not bringing that to the risk committee. Oh, you left that gap there and you never talked about it. It didn't hit your risk register. Oh, you put it on the risk register, but you didn't look at it for years and you left it there, right? We all know what that practice is, and I think this is the difference between kind of doing what we do and then that higher echelon of where we want to go. If you move into this area, it's really defendable because you have all that paperwork that John Barker's talking about, and you've got the practice that goes with it. The problem is this is hard to do. It's not easy. It's more than paperwork because it's actual practice that the paperwork reflects. And that's where I think most organizations, it's hard. If you're ISO certified in this kind of way, this kind of comes natural. You know how this is done. But if you're not certified like in that way, it's a big change management to go from kind of how you do security today to what that goal would look like. So I think each of you can kind of think about where you are between maybe, you know, on that spectrum and how that's going to look to the government.
And let me say real quick, I think the touchstone should not be perfection, nor trying to present perfection, but of continual improvement on a prioritized basis. I just wrote an article for Reuters. I talk about the gap between the perfection or what you present to the public and the reality of what is or what you talk about internally. The bigger that gap, the bigger the potential for liability. So I think it's better to talk about continual improvement, accuracy both publicly and internally that reflects reality.
Wonderful. We've got time for one more question. Let's do it.
From a non-attorney perspective, can we gain any insight using this case to the new cybersecurity disclosure laws? Or I'm surprised given the outcome that they're not getting slapped. Or are they just getting lucky having this occur prior to the new SEC reporting laws?
Well, I think it's in flux right now. We don't really know what the outcome is going to be in the SolarWinds case, but we can look at the enforcement actions. Mr. Bandler mentioned the 4 companies that received fines who were victims of the SolarWinds breach. You can look at that collectively, and you just develop best practices, which we have tried to bring out in our presentation today. And Mr. Bandler also noted how you're always continually improving, and I think if you can show that progress, you're going to be in a much better legal and regulatory posture.
And I would say some principles hold true always in life and law if we're going to live in the society we want to, which is that truth matters, following the law matters, being reasonable matters, that we're not going to be held to a perfection standard, that we're going to be wrong sometimes, but we also want to be accurate in what we say and do our reasonable best. Not live in fear that, oh, I'm going to get sued or this is going to happen, I'm damned if I do, damned if I don't. But we just try to do our reasonable, honest best to comply, to protect, and do our mission.
But I think to answer your question more specifically, because it sounds like, if I interpret it correctly, you're asking about the SEC disclosure rules. And though it is a different topic, and they did kind of skip out on that to a certain extent, right? There's a lot of confusion about that. And we know that from the cyber side. A lot of stuff happens. Incidents are happening all the time. And not only do they happen, but how do I declare them publicly? Not only once I declare them, how much do I want to say? And I feel that our relationship between our organizations and the government is not clear in this place, because I think as security professionals, we know we shouldn't give too much, because otherwise you're creating a vulnerability publicly. At the same time, we're scared because we don't have great guidance from the government as to how it should be declared. I thought I had an incident, but nothing was taken. Do I need to do that? And I just feel like our profession, and again, I concentrate a lot on this relationship between the attorneys and the security professionals. Our relationship and our law just hasn't matured enough to understand what is reportable and what isn't. I mean, I think legal departments are, debating, flipping coins. Like, nobody knows exactly what to do, and the stakes are high. I mean, I don't want to be flippant in that way. The stakes are high, but I don't think it's clear how and when we should report. I mean, there is no doubt if I find my data outside, it's being sold, I got to do that. But there's so much, so to speak, breakage into our environments where nothing has been taken and nothing has changed. What do we do with that? And I think the SEC disclosure rules just kind of, muddy that in a certain way, because we didn't know what to do with it before we were told, that we have to now declare it in some very public way. So it's unclear. It really is. And I think, again, we'll probably make better decisions the more the attorneys can actually talk to you and understand the jargon and so forth of what you're talking about from looking at the logs and understanding what happened from the logs, and then trying to put it in legal context. Because I feel like what's going on is there's just a lack of understanding. The attorneys don't understand it well enough to make a decision.
But there's always
And,
going to be
well,
this.
Sorry, team, on that happy note, I do have to wrap things up here. So before we go, though, can I see a show of hands? Was this session helpful to all of you? Wow, wonderful. That's great news. I want to thank you for that. And on behalf of the team here, I want to thank you for joining us here today, and we hope that we'll see you all sometime in the future. Thank you very much.